So good afternoon or good morning, everyone. Thank you very much for attending our webinar today. Someone's texting me, apologies. So just to start off, my name is Eoin Ó Catháin. I'm a board member of NAPAMA and the chair of the Canadian Executive for NAPAMA. This is a arts on the line, and we are delighted that this panel has been organized today. And so this is from CAPACOA and NAPAMA, and it is we are very delighted that Gowling WLG has agreed, and also the second time they've done something. Last time was in May, I believe, Susan, for Force Majeure. So I'd just like to give a quick introduction and then we can begin. Susan Abramovitch is one of the world's leading entertainment lawyers and a Toronto-based Gowling WLG partner. As head of the Entertainment and Sports Law Group, her practice covers transactions and disputes in the music, film, television, theatre, fine arts, multimedia, video game, sports, esports, and book publishing industries. Alexis Vaughhan is an associate in the Intellectual Property Group in Gowling, Toronto office. Her diverse practice focuses on intellectual property litigation, life sciences, and all aspects of entertainment and sports law. So over to you, Susan, and thank you very much again.
Hi, everyone. It's really a pleasure to be with you guys again. And I'm particularly pleased that our first webinar was about force majeure, which is more about everything going wrong and what you can do about it or not do about it. But today, we're being more productive and talking about how you move on with this new world that we're faced with in the terms of the performance arts world. So sorry to leave this legal disclaimer on the screen longer than I had to. This is, what my firm makes me say. But what you should take from it is that while we are Canadian-based lawyers, I've been doing entertainment law for 25 years, and I can tell you that most of the concepts will be applicable and helpful to those of you who are outside Canada as well. So please continue to stay tuned. All right, so just the way this webinar is going to work is we're going to give you a quick overview before we get to your questions that you've submitted, because I think it's important for us to set the stage, so to speak, in terms of what rights are at play, and then who you need to get rights from, or what kind of rights you need to pursue for various productions. I know the audience is diverse in the sense of different kinds of performances that you put on, or that you sell, or that you're involved with. So we'll try to address all of them, but it is important to get the nomenclature and the stakes set before we start answering your questions. So we'll spend about 5 or 10 minutes just doing that, and then we'll turn to your questions that have been previously submitted. While they have been previously submitted, I see already somebody submitted a Q&A. There is a Q&A function on the Zoom webinar. We encourage you to ask questions. I think that we have a lot of content to get through in this hour, but don't be discouraged. Submit your questions. If we can answer them during the hour, we will. If not, we will try to find a way to answer them in some other fashion, whether it's with follow-up emails or follow-up thank you. We'll figure it out, or maybe even a second webinar. So what are the rights in play that you're going to have to deal with in terms of protecting your rights or acquiring rights to put on productions in terms of live streams or on-demand streams? So the first and major one, and I'm sure this is not going to be news to any of you, is copyright. Copyright is basically created by statute, and it is a right that protects literary, dramatic, artistic, and musical works, as well as performances, sound recordings, and communication signals. So this, copyright isn't one right. It actually should be called copyrights or something, because it's really a bundle of different rights that can be parsed out to different people for different lengths of time and for different territories. So these different rights include the right to perform the work in public, the right to reproduce the work, to make a copy of the work, possibly the right to synchronize a work, particularly a musical work, with another performance of work. So basically, when you're trying to put something on, or if you hold copyright, you need to figure out which of these particular wheat sheaves you're going to need to acquire or deal with for your purposes. And they, as we'll talk about soon, differ based on whether you're doing a traditional live performance versus a live stream versus an on-demand stream. Because, of course, a live stream doesn't involve making a reproduction, whereas an on-demand stream or an archival copy of a performance involves making a copy. And in copyright terms, that's a different right than actually putting on a play or a musical performance. I should mention that copyright law differs jurisdiction to jurisdiction, meaning country by country. And so while there are similarities and there are treaties that require that there be similarities between different countries' copyright laws, sometimes there are differences to be considered. In copyright, just to clarify, copyright doesn't last forever. If you own copyright, it's subject to a term. That could be, in Canada, it's usually lifetime of the author plus 50 years. In other territories, it's more commonly life of the author plus 70 years. And when that term is over, we say that the work falls into the public domain. That's a very technical term. It doesn't mean that it's on the internet and you can go take it. It means that it's fallen out of the term of copyright. And when that happens, that means that you can use the work without authorization from the owner. The other thing to know about copyright is that even when you figured out which of the particular copyright rights you need, you also have to think what work you need it from. And we'll talk a bit more about that later, but a good example, you may need to get rights for one thing may have overlapping copyrights. For example, when you talk about music, you may be talking about a sound recording, which is one copyright, but by definition, which embodies a musical work, which is another copyright. And very often those two copyrights are owned by two different people. So that's something to consider. We'll talk about that a bit later. So let's move on to the next one. The other right in play is moral rights. Moral rights is a creature in Canada of the Copyright Act, but it's different than the Copyright Act. It's a right to be associated with the work or to decline to be associated with the work, and the right to the integrity of the work, which is defined in the Act, and we might get into that later. The important thing about moral rights to remember is that just because you might assign copyright or license copyright to somebody, if you don't specifically waive your moral rights, you retain them, you being the author. And so depending on which side of the fence you sit on, you may or may not want to get a waiver of moral rights. Third right in play that you need to consider are personality rights. So these are distinct from copyright or even moral rights. And these are the rights to someone's name, likeness, image, any kind of indicia of their personality. And it's important to keep this in mind because, your work, first of all, may portray personalities, and that's a complicated area of the law. You may or may not need to clear personality rights for that. But certainly when you use somebody's personality in order to sell a work, for example, in marketing campaigns or perhaps on merchandise items, a t-shirt, you would have to go to the individual and get those cleared. And then finally, if you're performing in a venue, you're going to need to, unless you own that venue, you're going to need to clear rights with the venue owner or the location owner where you are putting on a performance. Next slide. Thanks, Alexis. So who are the players who have rights that you may need to acquire licenses from or rights from? First, of course, you need to get rights to the content. That's the underlying work. And of course, depending on the work, it could be different things. It could be a play, so you may have to go to the authors or the playwrights, a dance piece, so you may need to go to the choreographer. If it's if you're putting on a concert, or some kind of music performance, you may need to go to the songwriters and publishers, recording artists and labels. So these are the types of people who you may, or their agents or representatives or collective societies you may have to go to acquire rights to put on the performance, regardless of how you're putting on the performance. Then there's the performers. So, you need to look at the people who are actually doing things in order for the performance to take place, such as the performers and the creative crew. Then, of course, as I mentioned, you would have to clear the venue unless you own it yourself. You might want to, sorry, I skipped over personality rights. Of course, anybody's personality who you wish to use in marketing materials. or in other fashions like merchandise you would need to clear. And then there's other considerations. You may need to consider going to collective societies who have been entrusted with administering very specific rights exclusively. For example, the one that comes to mind is public performance of musical works or sound recordings. That is a collectivized right. And so you may not be able to acquire a buyout of that right from the owner of the copyright in a musical work, for example. You may still have to pay SOCAN, the collective society, which administers the public performance right in musical works. So that's something that you always have to keep in the back of your mind, as well as unions who may have created collective agreements, or professional associations who may have minimum standards that cannot be breached if you're using their membership or contracting with their membership. Thanks. Alexis, over to you.
Thanks, Susan, and hi, everybody. I'm going to talk briefly about the different types of rights and permissions that are needed to produce a traditional live performance versus a live stream performance versus an on-demand or time-delayed stream. And I'll explain what I mean by each of those terms very briefly. So in this context, a live stream is a performance that is available to an online audience in real time. The performance is broadcast immediately and a recording is not produced. So obviously a recording would not be publicly available at a later time. In that way, it's kind of analogous to a traditional performance. And for stream performance in general, there may also be a live audience in the theater. Now, what we refer to as a time-delayed or scheduled stream is similar to a live stream in that the performance will be available online only during a specific scheduled time. However, the performance is not available in real time. It's recorded and available later. Practically speaking, this means that the performance is filmed using one or more cameras, and that recording will be made available online later. So the time delay allows for the possibility of video editing or splicing together footage, but whether or not you have permission to edit or modify a performance or recording of the performance is going to be set out in the terms of your license. And finally, an on-demand stream is a different category. And what we mean is a recording of a performance that will remain available online for an extended period of time. So think of the availability of a typical video on YouTube or Vimeo. A viewer can choose when to watch and typically can watch as many times as they want. Now this graphic is meant to illustrate the layers of rights that are required to produce the different types of performances. At the core, in blue, you have the rights that are required for a traditional live performance. And the next bigger circle represents the rights that are required for a live stream performance, which are in addition to the core rights that are required for traditional live performance. And finally, the last layer is on demand, or the time-delayed scheduled streams. And these performances require even more rights and permissions than the first two, since, as Susan mentioned, a recording is being made. So this slide outlines the first layer of rights that are required to produce a traditional live performance. And I imagine that most of you are very familiar with these. I'll go through them briefly. You need permission to use the content or exploit the copyright, as Susan mentioned. Typically, the license used for traditional theater performance, including grand rights or rights to perform a play, either do not include the right to make a recording or include very limited permissions to do so. So typical terms allow small portions, from 30 seconds to 2 minutes to be used for promotional materials, or there might be a carve out for archival use of a recording. But generally, the standard performance license does not allow broadcast and or public screenings of recordings. There's also copyright in the performance. So in a traditional performance, there's a separate copyright in the specific performance produced. The creative crew, like the director, choreography, setting, costume, light, and sound design, have used their skill and judgment to create a specific and unique version of the show that's replicated from night to night throughout the run. And this is a separate copyright. In Canada, if the creative crew are independent contractors, they will typically be the first owners of the original work that they've created, unless an alternate arrangement has been made through contract. And there's also the personality rights that Susan mentioned. You know, they come into play a lot in the context of marketing and promotional material. And usually this is baked into the standard contracts with talent in order to use their names and images. And venue, so permissions from the venue, such as you know, holding the performance there, rehearsals that might be required, on-site sales of merchandise, and perhaps use of ticketing facilities and their staff. So the next layer is live stream. And so you must clear and obtain all the rights that are required for traditional performance, but with additional uses. So specific permission is required to broadcast or live stream, and this permission must be sought from each of the groups that we've gone through. So the performers, the creative crew, and the venue. As I've mentioned, the typical license for traditional performance does not include any right to broadcast. So this is a separate permission that has to be negotiated and sought from the copyright holder or the organization that administers those rights. Note that usually in the past, these organizations haven't been empowered to grant these licenses. So they might direct you to the rights holder directly. And I think we'll discuss more on this later when we go through your questions. And this slide, the last point there, also sets out some of the considerations when negotiating permissions to live stream a performance, or ways that a license can be limited. So for example, a license might limit the stream to a specific video platform or host website, or limit the stream availability to specific areas or countries, and this is known as geo-blocking or geo-fencing. Access may be limited to ticket holders or subscribers via password protection. And in this case, payment of royalties for online ticket sales might also be required to be paid to the copyright holder. Finally, the biggest layer on the outside there is for a performance that's time delayed or on demand. And as Susan mentioned, a reproduction of the performance must be made in order to facilitate this streaming, which triggers additional rights. A sync license may also be required for the incorporation of musical works and sound recordings into an audio-visual work, like the video of your performance. And for certain works, a single individual rights holder may own all of the rights, which might simplify the negotiation, but it's not always the case. So it depends on your specific work or show. The terms of the contract might also specify how long the performance must be posted or might be posted. So it's an additional consideration for this type of performance. Will it be up for a day, a month, indefinitely? And of course, the other considerations that I mentioned in the previous slide may come into play here, like will the performance only be available to those who purchase a ticket, or will it be available to the general public for free? And I'll now turn the discussion over to Eoin to lead us through some of the questions we've received from the audience.
Yeah, thank you. So we did open for questions. So here are a few laid out. Let's see. Dealing with ownership and assignment, licensing of copyright. Should the artist always retain ownership of the product?
Right, that's a very big question. I mean, one thing that you're going to hear a lot from me today is that basically the answer to the questions is it's what you negotiate. Subject to the artist being able to control and alienate those rights, because there may be collective societies that already control particular aspects of the rights, and also subject to union requirements, you know, setting out minimum thresholds that may involve ownership. There may be collective agreements that say that a particular kind of artist cannot alienate ownership of copyright as a minimum standard. Subject to those two things, it really is what you negotiate. So sure, everybody wants to get ownership from the artist wants to retain ownership, but how much is being paid? Is this, you know, what's the difference in the leverage of the parties? You know, is this a big theater producer with a burgeoning artist who's excited to get their play being made? So it's really a matter of the leverage of the parties, the negotiation, what the other deal terms are. I would not say that the artist should always retain ownership, because it, you know, really depends on the situation.
Okay, thank you. How should we calculate composers' rights in the licensing of videos with music? The duration of the posting, the minutes of the music, the numbers of views.
Right. So before I even get into this, I want to reiterate something that I said pretty quickly during the slides. Whenever we're dealing with music, it's super duper important to remember that there's potentially two rights. The right in the sound recording, if you're using it, and the right in the musical work. You'll always have to clear the musical work, because of course without musical work, there's no music by definition. But there may or may not be a sound recording that you're using. So let me give you an example. If you're putting on a play and you want a performer in the play, or any kind of performance, you want that performance to use, to have an actor sing an existing musical work in the play, well, you have to get the right to, use the musical work. If you play a sound recording as part of that performance of that musical work in the performance, in the background, or you turn on the radio in a play and something, recording plays, that's two separate rights. So you have to make sure that, the rights to both the sound recording and the musical work have been cleared. So let's just start with that, because I think that's a cause of confusion for a lot of people. But back to your question, how do we calculate composers' rights? I mean, again, this is all subject to negotiation. There isn't a rule of thumb that says if you use 3 minutes, you pay X. If you use 10 seconds, you don't have to clear it. There's no rule. So let's start with de minimis uses. In the Copyright Act, it says that the copyright holder controls the substantial use. So, or put another way, copyright infringement is the unauthorized use of a substantial part. And so, if you're using a non-substantial part, you don't have to clear copyright. So, of course, the big question here, Owen, I know you want to ask me is, okay, so how many seconds is a substantial part? Well, unfortunately, I'm going to have to give you a lawyer answer here by saying it really, is defined not just quantitatively, but qualitatively, and will depend on the situation, and ultimately will depend on what a judge thinks it is if it ever goes to litigation. So that was a really lawyerly answer, but I usually advise people, no matter how small a portion you think you're using, it's always safer to clear it. I'd rather be, debating it in a negotiation than in a court of law, whether it's substantial or not substantial. But beyond that, assuming that you're trying to clear, I mean, obviously, how much of a song you might be using may dictate or impact what you end up negotiating. But what if it's like the essential, 3 notes of a song that, makes a song, immediately recognizable, and it's used throughout a performance or a play or whatever? I mean, really, you have to contextualize it as well. And again, there's no rule that I can give you, even with those parameters of how much you might pay. It is what you negotiate. The other thing to remember is that even if you do a deal with a composer for the right to use their musical work in your production, regardless of whether you're doing it live streamed, or on demand, you may not be able to acquire all the rights. And again, I touched on this, but I want to go back to the fact that public performance rights are pre-assigned by a composer to SOCAN, the collective society that administers it in Canada. And SOCAN has, the equivalent of SOCAN in the US is BMI, ASCAP, or CSAC. And each of those collective organizations have affiliations with similar organizations all over the world. So when you affiliate with one, they're collecting for you all over the world. In Canada, you cannot, you've pre-assigned the right. So if you're a composer, you can't then say to somebody, okay, don't worry about SOCAN, I'm granting you public performance, just pay me, a flat fee. You can't do that in Canada. It's different in the US. In the US, you can, the rights given to the societies are not exclusive. Alexis, do you have anything to add to that? Just feel free to jump in if you do.
Or no, I think you covered it.
Okay.
Great. So the next question is, can a producer buy out the rights of the performers or composers for video production to be licensed? What are the pros and cons for producers, performers, and composers? What about other parts of the creative team, director, lighting, sound, editor?
I bet, Owen, you could answer that question now, given my answer to the last two. It's really subject to negotiation. So can you buy out? Yes. Do you want to buy out? That depends on the situation. So one thing I always advise my clients is, whether you're a licensee or you're trying to acquire the rights outright, be careful what you ask for. I mean, obviously, the easiest thing to do is to say, okay, I don't know how I'm going to exploit this work ultimately. I know right now I'm just going to do a live stream, but who knows, maybe in 5 years I'll want to do something else with it. And maybe somebody will come to me to use a clip for their production or on a TV show. And if I haven't cleared the underlying rights for that use, you know, I'll feel bad because I won't be able to license it to them. So it's the easiest just to say, I want worldwide rights to use it in any way possible. And, you know, so please give me that, or I want to buy out the rights completely. That's great. That'll give you a lot of rights for sure, but it'll also cost you a lot of money. And a lot of my clients make the mistake of saying, well, I want the broadest possible rights. I'm like, that's fine if you want to pay for them. But if you want to, you know, pay, if you have a limited budget, you're going to want to carefully circumscribe your ask for rights to what you actually will need. Now, that may be what you need immediately, might be what you need in the future. And there's ways of crafting contracts to deal with potential things in the future that might happen but might not without paying them up front. For example, you could structure, whether it's a buyout or a license, you could say, okay, well, right now I'm just doing a live stream. So please license to me this music for a live stream. I'm only going to do it in Canada. I'm going to geo-block the rest of the world. We'll talk about that later. And I only need it for a month because or for this one day. That's all I need right now. Please quote me on that. But we may want to offer this on demand. We may want to expand the territory. We may want it for a certain number of years. We may want it for a longer period after that. All these are possibilities, and you ask them to quote for options to extend the rights to those, whatever the package of rights are. And by doing that, you say, okay, I'll pay what I need for what I need now, but please quote me and give me the right to opt to extend the rights, and in exchange for paying whatever you quoted me. And that becomes part of the deal. So you know today that 3 years from now, if you need to get those additional rights, you know exactly what you have to pay for. You don't have to go back to the drawing board once your production is a huge hit and the licensor wants to basically ask for a lot more money down the line. So that's a little tip. But back to buying out rights completely, again, keep in mind that certain rights won't be able to be bought out either because of union minimum standards or because of the collective societies having control over those rights, like public performance. I've already talked about that. So that's, I think, what I would like to say about that.
Great, we're flying through these. There's some more in the Q&A in a section, but we're just to the next question on this subject. Do licensing costs vary from region to region and depending on exposure, limited access or open access?
Absolutely. Again, collective societies exist in different territories and deal with setting rates and tariffs in different ways. So from a collective licensing perspective, you may be dealing with different rates. You may be dealing, so territoriality with copyright, one thing that I want to mention is that rights in copyright is dictated by the statute of the jurisdiction. So if you're licensing copyright for the territory of Germany, you have to look at the German Copyright Act and how it's governed. And so you may, and there may be different owners in different jurisdictions. So if you want to get rights from region to region, you may be dealing with different parties. You know, the owners may be different people in each country. So in that way, when you negotiate, you may be negotiating with different parties region to region, which may impact the cost. Oh, and you're on mute.
Thank you. I believe then we're on to on discussions on personality rights. I'm just going through Alexis' sheet.
Sure. Maybe I'll give a deeper dive into personality rights before we begin. So I mentioned that personality rights and they're known as sometimes as misappropriation of personality in Canada or appropriation of personality. In the US, sometimes they're called publicity rights. So these are rights to use the name of a person, their image, their face, you know, their voice. I've encountered cases, not personally, but in the case law, where typical expressions of comedians are used, and that was an indicia of personality in that case. Sound-alikes and look-alikes, so you don't have to use necessarily the person's actual face. It might be a look-alike that may trigger personality or publicity rights. So that's what we're talking about, the subject matter is. And the idea is, if there is value to your personality rights or your image, and when somebody uses it without consent in certain contexts, there's a right that needs to be cleared, or put another way, if they don't clear it, you may have a cause of action against them. The problem with personality rights is that, first of all, it's governed in North America state by state and province by province. So if you want to put on forget about North American, just even a national US or Canadian production, and you're using somebody's personality rights, you have to consider the law of 50 states and 3 territories and 10 provinces, which is overwhelming. The law differs from state to state and province to province, and I can tell you, for my province, Ontario, Canada, the law is pretty much unclear. It's not in a statute. It's created by the common law, which, put another way, is by case law. And I would say, a rule of thumb, but again, keeping in mind that it's not clear what the law is that at least in Ontario, if you're using a personality or an indicia of somebody's personality as the subject of a work, you probably don't have to clear it. So if you're doing a play about Susan Abramovitch, please go ahead, everybody. Alexis, I see you laughing there. But if you're using somebody's personality to sell something, like on a poster for a play about Susan Abramovitch, that might be different. Or on merchandise, or an ad campaign, or in a commercial. I mean, those are obvious ones. So that's kind of where I line things up when clients ask me. I definitely think it's better not to take it. I always, as a contract lawyer, not a litigator, it's better to get the rights up front and not have any uncertainty about it. But there are definite differences. Some states and provinces have statutes that dictate how personality rights are to be parsed. So it's kind of a tricky area. Now, you have, again, I talked about making sure that you're only going after the rights that you need. You don't necessarily have to get somebody's personality rights. Again, if you want to do something with somebody as the subject of the work, maybe that's okay. But if you want to use that or a performer's, let's say you have a performer and you're contracting with the performer to perform in a play or in a dance show, you do that. But then, are you also expecting to use their name and likeness in the promotional materials for that production? Are you expecting them to use their social media platforms to help promote? So that's also, they're not indicia of their personality, but it's tied to their personality and actually asking them to conduct other services. So you should really think through, it's not just that I want this person to perform in my work. I may want them to do other services that involve their person, or I may want to use other aspects of their personality in order to help put this production on. And when you sort of think it through like that, then you know what you need to ask for. And again, ideally you think that through before you engage that performer so that it's in that one contract that you enter into up front.
So on the same discussion point, personality rights, do you have any language suggestions for using avatars of the artists along with their recordings?
So avatars, very interesting development for the performance space. In fact, before everything got shut down, we were busy writing an article about a fascinating topic that I liked, which was all these concerts that were being put on with holograms of dead people like Tupac Shakur and who was the other one? Alexis, do you remember?
Was it Michael Jackson?
Definitely Michael Jackson was one. There's another guy, I forget. Anyway, some big, like 50s rocker. And I was fascinated with that, especially since it's, it involves personality rights of dead people. And of course, that's another aspect of personality rights, which is very unclear. Do they survive the death of the person or not? And again, state by state, province by province may have differing views of that. So avatars, and of course that kind of, the hologram on stage went away with the shutting of theaters. It may be coming back now, but more importantly, we just saw the success of concerts within video games with the Fortnite Travis Scott concert that everybody watched. And that used an avatar, which was a portrayal of the artist. Now, for many reasons, I don't think anybody could attempt to do that without getting rights from the artist, the music artist in this case. You need rights to his music, which might have been owned, probably is owned by some other entity, but still would probably require his consent. And then he's actually performing within the video game, so of course you're doing a contract with them. But interestingly, the use of an avatar involves a couple of rights. So first of all, clearly, I think in this case, you probably would have to get the personality rights granted from the person who's portrayed by the avatar. And they'll likely want to have a large say over how they're portrayed. In fact, as I understand it, technologically, in order to make this avatar work well, you would want to maybe motion capture certain, the actual artist in how they move so that the avatar actually looks like them when they're performing on stage. That's one. But also the avatar itself that's created would have copyright in it. And so you also are going to have to be careful. And when I say you, there's a lot of players here. Is it the artist who wants to be careful to own the copyright to that avatar that was created by somebody else? Is it the artist or the computer scientist who created the avatar? Is it the person putting on the production? So there's a big question there, but there definitely is copyright there that needs to be acquired, that is owned by somebody, may need to be acquired by somebody else, whether by assignment or by license. So very interesting area and I think we're going to write an article about it, so stay tuned for that. And I have a feeling we're going to see a lot more developments legally and otherwise in this area.
Thanks, Susan. Just, I'm looking at chat as well, and just a quick question, which someone asked. The copyright law Susan is referring to is a Canadian law, yes? Just so you can clarify a point you made at the start.
Yes, so I'm not sure exactly which reference you're talking about, but in Canada, copyright is governed by the Canadian Copyright Act. In the US, there's a US Copyright Act. In other jurisdictions, there are other legislation that governs copyright. And actually, this is a good segue into a point that I want to make about territoriality. I kind of brushed over it before, but copyright is a right that's governed country by country or jurisdiction by jurisdiction. So if I create a song or any other work that's governed by copyright, the determination of whether it's governed by copyright, whether I have copyright in it, and what that means to have copyright in it, what rights do I have, how long do I have them, what constitutes infringement, all those things is dictated by that particular, each country's copyright law, which could be legislation. It typically is. It might, in some places, it might not be governed by legislation. It might be governed by case law. And so if I create a work, I have a Canadian copyright. I have a US copyright in it. I have a German copyright. I have a UK copyright, right? I have a copyright in each place. And just because I'm Canadian and I'm, based in Canada, doesn't mean that the Canadian Copyright Act is the end of the analysis. If somebody wants to use my musical work in the United States, that's governed by the US Copyright Act, okay? So somebody asked a question, I don't want to it's beyond the scope of this webinar to talk about fair use or fair dealing. But in the US, there's a concept of fair use, which is a defense to copyright infringement, or put another way, which I don't like to say, is a user right. But basically, if it falls under a category of fair use, you're not infringing copyright. You're allowed to use somebody else's copyright. In Canada, there's a similar but different, not completely overlapping concept called fair dealing. So if somebody is doing a documentary in the US and wants to use my music and wants to, depending on the context, wants to argue that they're excused from getting permission to use my musical work in their documentary in the US, they wouldn't look at the Canadian Copyright Act fair dealing provisions to determine that. They'd look at the US fair use provisions. And the reverse is true too. If a US-based artist creates a musical work and I'm a documentary filmmaker and I want to try and fit it into my work without getting authorization, I have to look at fair dealing under the Canadian Copyright Act for the exploitation of my film in Canada. And in the US, you look at the US Copyright Act for exploitation in the US. So in order to answer questions, you look at where you're using the work, right? Where is the work being, as we say, exploited? Some people get offended by that word, but that's what we say. Where is the work being exploited? And it's that country's legislation, copyright legislation, that will govern the answer to the question. Why I spend a lot of time explaining this is because a lot of people, lawyers included, trip up. Sometimes they look at a contract that, you know, involves copyright. So it could be a license, you know, and it says, you know, between Susan Abramovitch, who, you know, for the license of a musical work that I created to be used in a performance of some sort. And I grant whatever rights are granted. And that contract, or the license at the end of it, says, this contract will be governed by the laws of Ontario, and disputes will be submitted to the courts of Ontario. When you choose law to govern a contract, like a license, that doesn't mean that the U.S., and it's the, you know, the laws of Canada and of Ontario, that doesn't mean that the U.S. Copyright Act is irrelevant now. Because you cannot, all you're choosing is the law that you use to interpret the contract, that governs the contract. And then it may also go on to say, or if we have a dispute, here's the jurisdiction where we have to resolve our dispute. But in resolving that dispute in the courts of Ontario and interpreting the contract under the laws of Ontario and Canada, it may, you know, it doesn't change the fact that in the US, or in a grant of rights, I may want to say that it's a work for hire, right? A work for hire provision is a US concept. And when I grant ownership of my copyright to somebody, even if it's a contract subject to Ontario law, that work for hire language will dictate what I've granted under US copyright law. So those are two separate things that should not be collapsed onto each other.
Susan,
Hope that answers that question. Yep.
If I may, is the EU considered a single territory? Sorry, the European Union considered a single territory?
There's, you know, this is beyond my competence a little bit. It's, you know, again, it's how the EU organizes its copyright law. There are, as I understand it, each country has its own copyright law that has to be, of course, you know, melded together because of copyright directives at the EU level. But that's like directives that dictate what the individual country's laws should be. So there could be differences still.
Okay, thank you. So next question, can you explain territorial release? If a venue is screening on their website, how can one contract for this?
Okay, so now that I've talked a lot about territoriality and the difference between copyright law territoriality and the law of the contract, and I hope that was clear. If it wasn't, please ask questions and I'll answer again some other fashion. But when you throw something on the internet, unless you geo-block, it's available throughout the world. And if it's available throughout the world, as I just said, it's where a work is being exploited. If something's being made available all over the world, it's being exploited all over the world, whether or not a user in a particular territory actually accesses it. And so the rights have to be cleared worldwide. Going back to another thing I said, where you're trying to acquire rights and you want to circumscribe what you're acquiring, obviously if you say, well, I want worldwide, because who knows, maybe this, you know, somebody in some territory will be interested in seeing it, that's great, but you're going to pay a lot more for it for a license worldwide than for a North American license or a Canada-only license or a German-only license. So you need to clear rights for every territory that's available. If you don't want to do that, or if you're not capable of getting the rights because they're not available to you for a particular territory, then you need to technically geo-block users from that territory from accessing. The other thing I mentioned, but I want to reiterate because it's really important, is that owners or agencies that may control rights typically will be or may be different territory to territory. So somebody who is a publisher of a musical composition in Canada, you know, may not be the publisher for the US or for Europe. And a lot of my artist clients have, you know, deals with music publishers or record labels all over the world. And so they have different labels depending on where you're doing it. So if you're seeking worldwide rights, not only may it may be expensive, it may also be extremely cumbersome to get worldwide rights because you may be dealing with a whole lot of licensors. Recently, it looks like, you know, theatrical licensing agencies have come on board some to help people access rights that they need to get. And maybe Alexis, you can talk a bit about that.
Sure. So the larger organizations that administer these types of rights, now on their website, some of them offer a simple type of sign up where if you have an existing license with them, you can add streaming rights. And a lot of the time they're classified under those same classifications I went through earlier in the presentation, live stream, scheduled stream, or on-demand video. Some of them have specific limitations baked in. So for example, some of these licenses are only issued when the stream is available on that organization's website. So they'd be responsible in that case for the geo-blocking, for ticket sales, and then for royalty collection and distribution. But it completely depends on the specific work that you're looking at and who administers that work, and also, of course, the territory and jurisdiction that you want to screen your work.
So just to throw in, by the way, that that we will be providing a link to this webinar and to the slides in case you missed anything. On to the next subject. Difference between Canada and US law. Are there significant differences between US and Canada regarding the use of music? Oh, actually, I beg your pardon. I missed one question going back to territorial and jurisdiction. What determines which country's law apply to film?
Right. I'm not sure I have an answer to that. I mean, or at least maybe I've already answered it. And there isn't one law that applies to film. It depends where you're exploiting the work. So if you're, and I don't know what you mean by film here. Are you trying to license a clip? Are you creating a film? Are you acquiring rights to a film? But wherever you want to exploit that film, that's the country's laws that you need to look at. And when I say laws, I mean copyright law for the purposes of the answer to that question.
Thanks, Susan. So on to, again, the next subject, which is differences between Canada and US law. Are there significant differences between US and Canada regarding use of music and film?
Yeah, there is. The big one in Canada, and this is actually a political hot button, is that the definition in the Copyright Act of sound recording excludes sound recordings that are accompanying cinematographic, I never say that properly, cinematographic works. Yep. In other words, if the sound recording is is synchronized with a film, then it no longer is a sound recording for the purposes of the act. And you might say, okay, well, that sounds lawyerly and legalistic, but it has a very practical implication, which is that if it's not a sound recording, then the public performance of that sound recording doesn't trigger what's called neighboring rights royalties. So there are royalties paid when there's a public performance or a communication by telecommunication, which is basically an electronic performance through the internet or by way of broadcast. There are royalties paid, or there's rights of remuneration for that in a sound recording. So if sound recordings played on the radio, then there's royalties paid, and they're called neighboring rights royalties. They're called neighboring rights royalties, I believe, because they're the rights that neighbor the equivalent rights for paying performance royalties when a musical work is performed publicly or communicated by telecommunication. Remember, I distinguished between sound recordings and musical works. Cowboy Junkies does a cover of Sweet Jane. Cowboy Junkies owns, or their record label owns, the recording. And Lou Reed, or his music publisher, owns Sweet Jane. Two different rights, okay? So in this case, sound recording, if it's in a film or television show, when that television show or film is broadcast, let's say on TV, because it's no longer considered a sound recording, there are no neighboring rights royalties paid, even though the musical work embodied in that sound recording would trigger public performance royalties when a television show or a film is broadcast on TV. So that's an important distinction that is not the case in the US, but in the US, the situation is different in any event because there is no concept of neighboring rights other than digitally for royalties paid and collected by an organization called Sound Exchange for the public performance of sound recordings over the internet. So those are some distinctions about music and film. I think we're at the end of the question, so that's exciting. We have a little bit of time left to go through some of the Q&A.
Yeah, so I've actually kind of taken a few questions. And just to say that I think we've discussed that questions that we can't get to, or maybe they need some research, I believe, Susan, they'll be answered at some point and left answers somewhere. I'm not.
We will try to get back. I've seen some of the questions are looking for template agreements. We're happy to provide those if you'd like to engage us. Some of them are a little bit outside of our field, and big questions. I saw the first question asked was about tax implications. That's beyond the scope of our expertise here.
Yeah.
But we'll try to answer as many as we can now and afterwards.
Well, I picked out a few like maybe you could. In relation to territorial, on live stream, it would be worldwide. So how do we word the contract so we are covered worldwide? Is that a possible thing to do?
Yes, absolutely. You can do anything in your contract. You just say, you know, that the grant of rights, the territory of the contract, you set out the rights that you need, and you say the territory of the contract is worldwide. But again, caution. Number one, I mean, if the party, the licensor represents and warrants that they do have worldwide rights to grant, and they have all the rights that they're granting in the contract, that's great. But you need to make sure that the licensor does control the rights worldwide. And when I say you need to make sure, if they say they do, it's very hard to actually go and do your own due diligence to figure that out. But it very often is the case, as I mentioned, that different entities own rights in different territories, so you may not be able to get that. And number two, you should also consider the limits of the rights being granted, because again, while you're getting worldwide rights for what you want to do, first of all, hopefully it's not violating any union requirements, but are there any collectively administered rights that you need to consider as well? Biggest example being the collective administration of musical works when they're publicly performed or communicated by telecommunication over the internet.
Okay, so another question that I've picked out. I'm picking questions which are less narrative based, which are very direct. So apologies if I'm missing your scenarios, but I think it's just for time wise. What does fair use allow you to do with the portion of work that is subject to copyright?
Right, so we touched on that. I don't want to get into too much detail because this is a complicated area. You know, I could bounce it to Alexis, who probably knows a lot more about it than I do. The main thing that I would say about this, and then Alexis, feel free to fill in the detail if you want. First of all, as I mentioned, there's fair use and there's fair dealing. Fair use is the concept under the US Copyright Act, fair dealing under the Canadian Copyright Act. And what those concepts do are, I would say, but it's a little bit political, excuse infringement. They're defenses to potential claims of infringement. The youngins today like to call it user rights. In other words, you know, rights of the user, you know, it's a right just like copyright, it's a corresponding right. You have copyright, that allows you to stop people from doing certain things. I have a user right, which allows me to proactively do things. Again, the distinction between that nomenclature is a bit political, so I'll leave that aside for now. But basically, it allows people to do certain things with works without getting clearance. So, for example, one of the big headings under fair dealing is news and reporting. So when, you know, something that has copyright in it is used for news purposes, that may fall under the rubric of fair dealing. There's other headings as well. I'll let Alexis name them. And then once you fall under a category, sorry, Alexis, put you on the spot. Once you fall into a category, that's not, you're not sort of at the end of the analysis, then you have to also go through an analysis that's been created by case law about whether your use is actually fair. So you can't say, okay, news reporting I can use as, you know, I can just put on, you know, show an entire 2-hour concert of this artist, because that may not qualify as fair as defined by the courts. Alexis, anything to add?
Well, I'm definitely not going to list the categories on the spot. But I think, I mean, you've hit all the major points, but I think one thing to recognize is something you said earlier in the presentation, that, I mean, a fair use, fair dealing analysis is complicated, and you can make arguments either way, but it's easier to kind of resolve this at the outset, to make it, to clear your rights and figure it out at the beginning, than to, you know, take your chances and litigate. And that obviously depends on who you are and your means as an organization. But from a risk reduction type perspective, I'd say that's the way to go.
That is an excellent, excellent point. that being said, you know, situations come up. I had one with a documentary that was being made on a very, very controversial subject. And there were certain things that could not be cleared by definition because you knew they'd never be cleared, but without them, you couldn't expose whatever was being exposed in this documentary. And so in situations like that, sometimes you do have to do the analysis because there is no answer of clearing, you know, for any price.
Just a question a general question I have. Is there a lot of case law and legislation because of things like YouTube and social media, or is this still a very kind of growing area that it's kind of developing, or we're figuring out as we go along?
We're definitely figuring it out as we go along. We did get an interesting copyright exception, as I call it, in the last round of Canadian copyright reform called we call it the YouTube exception. It's not specific to YouTube, but it's for user-generated content you know, when you use copyrighted material in your user-generated content for non-commercial purposes. That is not considered an infringement of copyright. As far as I know, that has not yet been analyzed under case law. Alexis, do you know of any?
No, I don't think so. Not any doubt.
Yeah, we're very interested in what that means because at this point in the world, you know, what does commercial, non-commercial use mean? You know, if I'm an influencer, you know, is that commercial? I would say yes. It is all being figured out. A lot of people don't understand. And when I say people, I mean people in these fields still haven't really parsed all the rights and all the remedies. Right now, you know, when you have content, you know, the YouTubes of the world and Facebooks have created protocols for content to be up there and for it to be monetized, and you can opt into monetizing your content with, you know, or putting in a takedown, and then, you know, you can always ask them to take it down.
Thank you. So I'm just going to ask one more question. To people who've submitted questions, I apologize if I haven't gotten to them. We did actually just have pre-submitted questions and we had some extra time. But just this last one, if you acquire written permission from someone, i.e. sync rights, is that the license?
Yes, that's exactly what it is. But again, sync rights, and I'm not sure if I explain that sufficiently. A synchronization license or synchronization rights are the rights to synchronize a musical composition or a sound recording with moving images. So, you know, my favorite sync of all time, just personally, if you want to know something about me, is the use of that middle part of Layla in, oh my God, what's the name of the film? Oh, it's like a mafia film. Oh, it's so good. Goodfellas. That is my favorite sync of all time. So in order to do that, the producers of Goodfellas would have to go to the person who owns the musical composition and get a sync license, and to the owner of the master, which would be the label that owns Layla, and get what's called, it's still synchronization use, but it's typically called a master use license. So you need 2 licenses to get that. But yeah, the document in which the right to synchronize the musical work or the master with your moving image is the sync license. Again, when you're doing it with a master, we call it a master use license.
So on that note, I would very much like to thank Susan, Alexis, Shannon, and Rachel, who are back there working their magic and helping this webinar happen. Also, Sue and Andrew in CAPACOA, and Chris and Ron in NAPAMA. So everyone, thank you very much. As we mentioned, there's a link in the Q&A that Shannon put up, where I think in a few days this webinar will be available to rewatch, and the slideshow. And also, eventually at some point, there'll be the answers to the questions we can get to. Will they be on the same link, Alexis or Susan?
No, they won't. I don't think they will.
Okay.
No.
Go ahead, Alexis.
We'll go through them and we can see what we can answer without a follow-up email. But there's a lot of very specific questions in there that will require some, you know, legal analysis. So, I mean, we'll see what we can do, but otherwise you might need to engage a lawyer for those very specific questions.
Thank you. And again, both of you, thank you so much. It has been an incredibly insightful webinar. We very much appreciate your time and your consideration towards the arts industry and arts professionals, and we hope to see you again. So everyone, thank you very much, and we'll talk to you soon.
Our pleasure. Thank you, Eoin.